Good morning, everyone. I'm Bob Fay. I'm a partner in the higher education and employment teams at VWB. And together with my colleagues, Jane Byford, a partner, and Charmaine Chowdhury, a solicitor, we're going to talk to you today about some disability discrimination issues for the higher education sector. As it says in the introductory slide, I am going to cover a relatively brief case law update. I think we're going to try to allow ourselves about 15 minutes each, so as to allow time to answer any questions you have. I've been through some disability discrimination cases from 2020 and 2021, mainly from the appellate courts, but not exclusively, and picked out what I think are some interesting issues relating to disability. I'm actually going to start with a case that's not particularly discrimination related, but is just came out last week and is a first instance decision that we think is quite interesting. So just to whet your appetites, there's something sort of hot off the press. And then Charmaine is going to talk to you about some COVID-19 related issues in the disability discrimination sphere before Jane finishes with some top tips for you on handling particular discrimination issues. The first case I'd like to talk to you about is the one I mentioned. It's Allette and Scarsdale Grange Nursing Home Limited. So this is a case that was published on the 11th of January, first instance employment tribunal decision. But it's interesting in that, as it says on the slide, Ms. Allette was a care assistant in a nursing home for dementia sufferers. And she brought a claim for unfair dismissal because the home in which she was employed dismissed her for, in its view, unreasonably refusing to follow an instruction from her managers that she would be required to be vaccinated in order to attend work, and because the managers in the home considered that her reasons for refusing the vaccine were not reasonable in the circumstances. Now, the events in this case all happened between December 2020 and January 2021, so substantially before the mandatory vaccinations for care homes came into effect in November of last year. So the employment tribunal's decision was that her dismissal for refusing to be vaccinated was not unfair when it happened in January 2021. The tribunal accepted that her fear and skepticism about the vaccine was genuine. It decided in all the circumstances that the requirement to be vaccinated was a reasonable management instruction, and she had no medical authority or clinical basis for refusing. Now, this is definitely not, as a first instance decision in a care home, a broad precedent for saying that refusal of vaccinations is a basis for any kind of disciplinary action, and the employment judge at first instance was at pains to point that out. There were a few key aspects of the case here that swayed the employment judge towards a decision that dismissal was in the reasonable range of responses. It included the fact that in December of 2020, this particular care home unfortunately had been hit with an outbreak of COVID-19, and that resulted in about half of its roughly 65 staff and 22 out of about 34 residents contracting the illness, and unfortunately a number of residents passing away as the result of contracting the illness. One of those employees who contracted COVID was Ms. Allette, and also in early January 2021, when she was being asked to be vaccinated, the national picture, just to remind you, was one of 100,000 recorded cases of COVID-19 per day, about 1,500 deaths per day nationally, with a large percentage of deaths occurring in nursing home settings. Also, importantly, the home's insurers had said that they would not provide public liability insurance for COVID-related risks after March of 2021. And thereafter, the respondent faced the risk of liability if unvaccinated staff were found to have passed disease to a resident or visitor. And similar issues applied to their employer's liability insurance. So the insurers were making it clear that they expected the respondent to insist that all staff were vaccinated unless they could reasonably justify the refusal. The homeowners were also of the view that as she was the only staff member refusing the vaccine, it would be easy to trace transmission to Ms. Allette and therefore make legal action more likely. When these issues were put to her, Ms. Allette's reasons for refusing the vaccination were found to be that she believed it was not safe due to stories that she had read on the internet, and she referred to a conspiracy around the vaccine. Later, during disciplinary and appeal proceedings, she tried to argue that in fact it was due to a religious belief as a Rastafarian, but the tribunal found that the employers genuinely did not believe that that was her reason for resisting the having the vaccination, and she made no mention of it. The tribunal found in initial conversations, and only brought it up when disciplinary action was coming to a conclusion. So the tribunal was happy that and no religious discrimination was engaged in. In fact, no religious discrimination claim was brought. The fact that she simply felt that vaccines weren't safe because of the information she'd gathered from the internet weighed into the tribunal's decision about range of reasonable responses. Another important point, so in response to Ms. Allette arguing that having caught COVID, she had the protection of natural immunity, the tribunal took into account the fact that at the time, the advice from Public Health England was that it was possible to contract and transmit the virus more than once, but that the vaccine reduced the risk of contracting it and its transmissibility to others once contracted. So the tribunal were very keen to take account of the state of affairs of public health information as it was known to the managers of the care home at the time. So there we go. As I say, it's just a first instance decision. It's very much on its facts and on the facts of the decision as it was made roughly a year ago as we're presenting this webinar. But it is an interesting one in the sense that it's, I think, the first decision we've seen where someone's actually taken action against an employee for refusing a vaccine. And on these very limited and particular facts, it was found that that was a fair thing for them to do. Most employers won't have the kind of pressing needs to protect vulnerable adults in their care that occurs in the care home sector, and therefore the balance of proportionality is likely to be different in the HE world, certainly. But as I say, an interesting case to have a look at. And then if we move on to the discrimination focused cases, I'd like to talk to you about Sullivan and Berry Street Capital. So this is a Court of Appeal decision dealing with claims for disability discrimination from Mr. Sullivan against his former employer, Berry Street Capital. As it said on the slide, Mr. Sullivan experienced paranoid delusions which affected his work. In fact, his employer, it appears, had concerns about his attitude in the office and his general timekeeping almost from the moment he was first employed. And his paranoid delusions at their worst involved a belief that he was being tracked and monitored by a Russian gang. He'd been employed by Berry Street Capital since 2009, and those delusions that were affecting him in May of 2013. So he'd been there a while when the issue started. They did affect his work, in particular his timekeeping and attendance. However, his condition improved as the result of medical treatment. And by September of 2013, he had reached a position where, whilst he still had this belief that he was being followed by this imaginary gang, he could manage that condition without letting it affect his work. Now, despite that improvement, his employer continued to have the same concerns about his timekeeping and attitude that it had had really since the start of his employment. And these concerns were raised with him regularly at reviews between July of 2014 right through to September of 2017, when he was finally dismissed on the grounds of capability. And then he brought his disability discrimination claim. And the decision that was eventually ratified by the Court of Appeal was that the claimant was not disabled in law as the result of his delusional beliefs. And the key takeaway from this case, I think, is the distinction that the Court of Appeal made between having a long-term impairment, which is part of the definition, as you will know, of disability discrimination, and having a long-term condition. So whilst Mr. Sullivan was able to show that he had a long-term condition, he wasn't able to show that the impairment he suffered as the result of his condition met the definition of long-term, which of course means lasting for at least 12 months or being likely to last for at least 12 months in the sense of may well doing so. So the Court of Appeal reviewed the facts of his case and found that, in fact, Mr. Sullivan had had two short-term, separate and specific elements of impairment as the result of his paranoia, and that taken on his specific facts, those can't be held to have been long-term. And so his claim failed on that basis. We often in employment practice and HR practice come across situations where employees' health does fluctuate, and you will often have reports from occupational health advisors that telling you about the prognosis expected for an employee, and you'll have periods, in fact, when the employees will return to work. And this case is not a precedent that allows you to assume that where there has been a period of improvement, then that is automatically cut off the one period of illness from the next period of illness. But in certain circumstances, it is very much worth looking into whether there are arguments that there is no long-term adverse impact because of improvements in health conditions. And this is Aleem and EACT Academy Trust. This is an Employment Appeal Tribunal decision where the EAT held that it was not a reasonable adjustment to continue to pay an employee a previously higher rate of pay after being moved to a lower grade because of their disability. So the facts essentially were that Ms. Aleem was employed as a science teacher at the EACT Academy Trust, which is a large multi-academy trust owning a number of academies. She had a period of sickness due to mental health issues, and as a result of that period of sickness, she became unable to teach. She asked to be allowed to teach for 2.5 days a week instead of 4 following her period of sickness. And the employer rejected that request because it couldn't be responsible, couldn't be confident of being able to get and maintain supply cover for the days when she wasn't working. She raised a grievance while off sick, but as part of the resolution of that grievance at an absence meeting review, she accepted the option of returning to work 3 days a week as a cover supervisor. Now, the cover supervisor role attracted a lower degree of pay than a normal teaching role. And so what the employer did was it continued to pay her higher teaching rate of pay during the probation period. And then as her grievance and appeal against her grievance were being resolved, it took a decision to continue to extend that high rate of pay until those grievances and the appeal against them were dealt with. And then it brought her down to the rate of pay associated with the supply cover role. And she brought a claim for failure to make reasonable adjustments on the basis that it should have extended her higher rate of pay long term. And the Employment Tribunal found, and the EAT agreed, that that was not a reasonable adjustment that EACT Academy Trust was required to make. And in doing so, it made it clear that part of the reason that that it had come to its conclusion was the clarity of communication between the employer and the employee around the period for which higher pay would be continued. And it said that from the outset, the employer had set the expectation that the increase was only on a temporary basis, and it had always been very clear about that. And that helped the ET and the AT to come to their conclusion that it wouldn't be a reasonable adjustment to extend higher levels of pay where there's been a change in role due to the effect of a disability. You're probably all aware that there's relatively strong tribunal precedent saying that in most circumstances, paying additional higher rate contractual sick pay is not a reasonable adjustment. And this is a useful case for employers in setting out that provided that you are sufficiently clear about your communications, there's likely to be a reasonable argument, a decent argument, if I can put it that way, that it wouldn't be a reasonable adjustment to extend higher rates of pay in a change of job role on a long-term or even permanent basis. And I'm sure that many of you will deal with situations of phased returns to work, where employees are coming back on reduced hours and gradually building them up. It's worth bearing this case in mind when you consider whether it may be a reasonable adjustment to allow employees to return with reduced hours, but higher rates of pay than are reflected in the hours. In many cases, it will not be a reasonable adjustment to make that kind of increase, but we have seen situations where employers have agreed to do it. I think one of the learning points from this case is the need to be very clear at the outset what your intentions are in relation to any additional pay you exercise your discretion to provide. And I'm already running over time slightly with the cases, so I'm going to speed up a bit dealing with Judd and the Cabinet Office, Rooney and Leister Council, and the other two cases I've got to go. So we're on the Judd slide now. So I'll try and put this relatively briefly. Essentially, Ms. Judd was employed by the Cabinet Office and offered a secondment to Montenegro. Unfortunately, in July of 2018, she was the victim of a crime which negatively impacted on her health and well-being. That was 2 months before her secondment was offered. In August 2018, she had 2 significant health episodes which resulted in her attendance at A&E, and the Cabinet Office required her to undergo medical clearance for the secondment, which was carried out by an independent contractor called Helix, which advised that her health was what it called high risk and recommended that she should not travel to Montenegro for the time being. And this was the first time that the Cabinet had ever had a high risk classification from this particular external contractor. Now, she also was assessed by the respondent's occupational health advisor, but failed to provide her full medical history at that stage. And the OH advisor, as the basis of that consultation, did deem her fit to travel, but made various recommendations of steps which she should take to protect her health whilst on secondment. So there was a clash between the external advisor's recommendation and the internal OH recommendation. And the Cabinet Office concluded that it was going to follow the external advisor's recommendation and withdraw the offer of secondment, at least for the time being, because the Helix advice was, for the time being, her health was not such that it was safe to send her. And Ms. Judd brought claims of disability discrimination and failure to make reasonable adjustments. The question before the tribunal essentially being whether the respondent had acted proportionately in withdrawing the offer, or whether it should have allowed the secondment to proceed with OH's safeguards in place. And you'll all be aware, I expect, that when assessing objective justification in reasonable adjustments claims, the questions are, do you have legitimate aims in the act that you take, and have you acted proportionately in the steps you've taken to achieve those aims? And in this case, it was decided that the Cabinet Office had indeed acted proportionately, and it was a proportionate means of achieving the legitimate aim of protecting health and safety of staff while abroad, and concluded that the occupational health recommendations would not have been sufficient to protect the claimant's health in an emergency, which I think quite crucially is a fact that the claimant herself admitted to when she was cross-examined on what would happen in an emergency situation. And during that cross-examination, accepted that recommendations by the Occupational Health Service would have been insufficient to protect her in emergency situations. So It's a case that demonstrates the importance of context and proportionality in dealing with disability-related matters and proposed adjustments in particular, and is, I think, some comfort for the employers in showing that when you take the time to identify properly your legitimate aims and balance achieving those aims with the impact on the employee, you can win those kinds of objective justification arguments and be found to have acted proportionately. Last two cases, Rooney and Leister City Council is a case in which the EAT overturned the Employment Tribunal's decision that the normal symptoms of menopause could not amount to a substantial impact on day-to-day activities. So this was a decision on a strikeout application, and therefore didn't determine the facts of Ms. Rooney's claim against Leister City Council. But it's an important decision in that the EAT held that the tribunal had made an error in law in deciding she was not a disabled person at the relevant time, and that Ms. Rooney in her evidence had stated that both her physical and non-physical symptoms associated with the menopause on the face of them may have been capable of amounting to the disability, and the tribunal hadn't properly engaged with deciding whether they had a substantial impact on her day-to-day activities. So the significance of this case is at appellate level a recognition that the symptoms of menopause might, in some circumstances, and it will be a factual assessment of the impact on each individual woman who's bringing any kind of discrimination claim. But in certain circumstances, they may well amount to a substantial disadvantage. It's not on the slide, but I'll also mention the case of Donaki and I think it's Talent, but definitely the claimant in the case is Donaki, which is a recent first instance claim in which a disability discrimination claim arising from symptoms associated with the menopause was also successful. So that goes a step further than the appeal decision here in actually upholding that the claimant was disabled and dismissing arguments that the typical symptoms of the menopause could not amount to a disability. We think this is an important line of cases because, firstly, for employers, the menopause is becoming more and more in the news and a topic of conversation and discussion in HR circles. And secondly, as taboos are broken down in regard to talking about the effect of women in the workplace of the menopause, employers are likely to need to or be better placed to engage proactively by putting in place policies and recognizing needs for potential adjustments around things like working hours, and being alive to the issues that menopausal symptoms can create on their employees, than doing what Leister City Council actually did in this situation by trying to argue that they weren't aware. Not only were the symptoms not sufficiently serious, but they weren't aware of them and couldn't have been aware that there was a disability in this case. So I think it's both this case and Donaki are an indication of a trend and a movement. I think we will start to see more positive engagement with the issues that they raise in employment practice. And finally, Seckham and Reed is another disability discrimination case where the employer was unhappy with the employee's performance and dismissed him. It was aware that Mr. Reed had suffered from a period of absence from work after a breakdown resulting from a traumatic event, and that it had had an effect on its mental health, which Reed deemed to be temporary, and then subsequently deemed him fit to work, and then shortly after his return dismissed him for poor performance. And before his employment with Reed, Mr. Seckham had suffered 2 previous periods of ill health relating to anxiety and depression. However, Reed were unaware of this history, and when joining, he'd responded in the negative in a question to an equal opportunities questionnaire asking whether he had any health-related impairments for which Reed might need to make reasonable adjustments. He also did not suggest any problems with his performance arose from a mental health condition during the performance management process. And so the tribunal, when assessing whether there was any long-term adverse impact that could amount to a disability, concluded that given the absence of reference to anxiety and depression in the medical notes in the intervening periods between his episodes, and given what he had said both during recruitment and during the absence management process, there was insufficient evidence to support his contention that there was a long-term impact on his ability to carry out day-to-day activities, and therefore found that he was not disabled. And the AT said there was no flaw in that reasoning, and upheld it. So second really takes us back to the second case that I mentioned, Sullivan and Berry Street Capital, in emphasizing the importance of looking at the specific information and evidence that's available about a long-term absence. So having run over horribly with the case review, I'll pass over to Charmaine now to pick up on her section.
So in this section, I'm going to talk you through the current position on requiring employees to attend the workplace, how the rules apply to disabled employees, the reasonable adjustments that can be made, and any potential claims of discrimination. So as you're all aware, from the 20th of January, employees in England are no longer required to work from home, but that doesn't mean that you can force employees to return to the workplace. So where you have a disabled employee who refuses to return to work because of a perceived increased risk in light of their disability, medical advice should be sought as soon as possible, either from their GP or occupational health, to confirm the potential risks and for advice on what adjustments should be made. Where the matter is urgent and there's insufficient time to obtain medical advice, you might wish to err on the side of caution. So if a disabled employee refuses to return to work because they're concerned about the implications of contracting COVID-19, then they might be protected from a dismissal under Section 100 of the Employment Rights Act, which protects employees from dismissal on the grounds of absence from work if the absence was due to a reasonable belief that attending work would put them in a serious and imminent danger. So the concept of danger has been broadly interpreted, but it could include the risk of contracting COVID-19 from an infected colleague or student, although the danger would need to be reasonably believed to be serious and imminent. The employee doesn't actually need to show that the danger existed, but it's a question of fact for the tribunal. But it underlines the importance of effective communication in terms of the employer taking measures to minimize risk. So as an employer, you'll be aware that you need to make reasonable adjustments for disabled employees, and that includes when the worker is working from home. So what is reasonable in light of the pandemic is not a particularly straightforward answer, but it can include things like changing the location where the job is performed, changing the hours of work, providing extra aids, such as specific computer software, and providing specific equipment like chairs and footstools. So as staff are now encouraged to return to the workplace, you can make reasonable adjustments to accommodate employees with a disability, such as updating and changing policies and procedures, and ensuring that temporary measures that support social distancing do not have a negative impact on disabled employees. It's particularly important to consult with disabled employees to find out what you can do to support them and alleviate any concerns they might have about returning to work. In terms of the potential claims for discrimination, there might be a case that requiring all employees to continue to work in a pandemic and to return to the office could be indirectly discriminatory against a disabled employee and those who share that disabled employee's disability. In that case, you could consider whether the requirement to attend the workplace could be justified as a proportionate means of achieving a legitimate aim. Where an employee self-isolates because of their disability and their employer treats them unfavourably because of this, either by not paying them or dismissing them for an unauthorised absence, the employee could have a potential claim for discrimination arising from disability. So the employer's action would be something arising in consequence of the employee's disability. So here, the employee could argue that that would be their need to self-isolate. And employers, as you're also aware, have a duty to make reasonable adjustments. So you should carry out a workplace risk assessment in respect of the disabled employees and consider whether any reasonable adjustments need to be made. So an employer could be liable for a failure to make a reasonable adjustment if it doesn't facilitate a disabled employee's request to work from home in a pandemic. However, where the employee's role is not suitable for remote working, it may not necessarily be a failure to make a reasonable adjustment for the employer to continue to not pay that disabled employee if they choose to self-isolate before seeking medical advice. So in this final section, I'm going to touch on shielding, the approach to take when dealing with employees who are cautious about returning to work, and the reasonable adjustments that can be made for a disabled employee. So, as you'll all be aware, the shielding programme for clinically extremely vulnerable individuals in England ended on the 15th of September 2021. And the government guidance says that you no longer need those individuals to shield, but it does suggest that they might wish to take further advice from a clinician on any additional measures. So some additional precautions can be things like checking whether the people that they're meeting have been vaccinated, continuing to practice social distancing, avoiding crowded spaces, and asking visitors to take lateral flows and wear face coverings. Where you have an employee who is more cautious about returning to work, you might wish to consult the ACAS guidance going to the workplace during coronavirus. It suggests that where the workplace is open and working from home is not possible, an employer and a person that's previously been regarded as clinically extremely vulnerable should talk as early as possible about how and when they'll return to the workplace, the steps that the employer has done to keep the workplace safe, any concerns that the employee has about going to work, any reasonable adjustments that can be made if an employee has a disability, and other adjustments like flexible working. The guidance does state that where a doctor has advised that somebody is high risk, they may be required to stay home, despite the fact that the shielding programme has ended. And in those circumstances, you should consult your sickness absence policy and sick pay rules. You should also talk to the employee to understand any concerns they may have and how best they could be supported. So employers should be mindful of the particular needs of those with protected characteristics and who are protected by discrimination law. So the Working Safely Guidelines suggest that employers should involve and communicate appropriately with workers whose protected characteristics put them at a higher degree of risk than other employees, consider what you need to do to make reasonable adjustments, make any reasonable adjustments to avoid disabled employees being put at a disadvantage, and to make sure that any steps that you do take do not have an unjustifiable negative impact on some groups in comparison to others. The overall aim should be that as far as possible, to remove or reduce any substantial disadvantage faced by your disabled workers, which would not be faced by a non-disabled worker. And you use return to work risk assessments as an opportunity to consider and monitor reasonable adjustments that can be made to support disabled employees to work safely. I'm now going to pass to my colleague, Jane Byford.
Thanks, Charmaine, and good morning, everybody. So I'm going to finish today with just giving you 4 top tips on managing disability discrimination in your university workplace. So my first top tip is managing associative discrimination issues. And associative discrimination issues is something that you need to be wary of. The definition of direct discrimination under the Equality Act is discrimination because of a disability. It doesn't say that that needs to be in relation to the employee's disability. So by implication, it can be in relation to somebody else's disability. And where we usually come across this is in relation to someone who has caring responsibilities for someone who has a disability, another person. So maybe a parent who has caring responsibilities for a child who has a disability, or perhaps an elderly relative or some other kind of relative. Now, associative discrimination isn't expressly covered in the Equality Act, but it does actually predate that act. And the leading case is Coleman and Atteridge Law. And there was a mother of a disabled child whose employer treated her less favourably and harassed her because she was a primary carer for that disabled child. And the EAT found in that case that although she wasn't disabled herself, she could claim direct discrimination and harassment because she was treated less favourably because of the disability of her child. And it said in that case, the EAT, that it didn't matter that she herself wasn't disabled. It was because of disability, because she had the caring responsibilities for a disabled child. So you need to be very careful, I think, about associative discrimination issues, particularly in relation to direct discrimination and harassment, because of disability definition of direct discrimination. So often asked whether the issue of associative discrimination also applies as far as reasonable adjustments are concerned. And the straightforward answer is no, it doesn't. There was a case of Hainsworth and the Ministry of Defence in 2014. And there was a civilian who was employed by the armed services, British Armed Services in Germany, to work in Germany. She wanted to be transferred back to the UK because in the UK there were educational and training facilities for her disabled daughter who had Down syndrome. Her request was refused, and she claimed that was a failure to make reasonable adjustments because her daughter had a disability. And the Court of Appeal said no, it rejected her claim. As far as reasonable adjustments is concerned, those only apply in relation to employees and potential employees. They don't apply where the worker isn't disabled themselves, but they're associated with someone who is. So the simple answer is it doesn't apply to reasonable adjustments. Also need to consider about indirect discrimination, and that is an area where it's a bit more unclear. There is one tribunal case that says that in relation to indirect discrimination, that here was a requirement to work on site, because of somebody else's disability, the associative discrimination did apply in that case. That's only a first instance decision, so there is a decision there, but we really need some appellant decisions before we know whether actually associative disability applies to indirect discrimination. So from a practical point of view, I think take proactive steps to prevent discrimination, make sure you're providing adequate training and awareness, and just be aware that associative discrimination is an issue. So if you're taking decisions based on not the individual's disability, but someone associated with them, then just bear in mind you need to be careful there and consider whether the disability issues, direct discrimination and harassment may apply in those circumstances. So if we can move on to the next slide, please, and my top tip 2, which is assessing long-term absence. As Bob already mentioned, in terms of the definition of disability, long-term under the Equality Act means it is expected to last at least 12 months, or it has lasted 12 months, or it's likely to last for the rest of the person's life. So really it has lasted 12 months or likely to last 12 months. There are some exceptions there. So some disabilities are deemed to be disabilities right from the point of diagnosis, particularly cancer, HIV and multiple sclerosis. So they're deemed to be from day one. So when you're looking at long-term disability, I think it's important that you continually are discussing and consulting with the employee whilst they remain on long-term sick leave. You're looking at the effect the condition has on them. You're looking at what you might be able to do to get them back into the workplace, long-term prognosis, and any reasonable adjustments you may be able to make. You can't just claim ignorance. If you know of or you should have been aware of somebody's disability, then you can discriminate, even if they haven't expressly said that the reason for their long-term absence is a disability. I would say that medical advice can be key here. A good occupational health advisor is very valuable, and I usually take advice from an occupational health advisor rather than from an individual's GP. And I think if you're talking about potentially dismissing somebody who's disabled, occupational health advice is going to be key there, and you need to tread very carefully before considering that. So if somebody has been off for a long period of time with a disability related illness or a disability, then you should be relying on medical evidence. You should be consulting with them, and dismissal really should be a last resort in those circumstances. But there are some circumstances in which you may dismiss. So if we move on to top tip 3, please. And that's always consider reasonable adjustments. Consider providing the relevant support and any reasonable adjustments that may be necessary. Where there's a provision, criteria, or practice that puts a disabled person at a substantial disadvantage compared with those who aren't disabled or don't have that disability, then there is this duty to make reasonable adjustments. And that's when you know or ought to have known that somebody has a disability. And it's a unique concept in relation to disability discrimination. It's actually treating someone more favourably in order to level up the playing field, to reduce or remove the disadvantage that that person suffers because they have a disability. And an employment tribunal will look and see whether it will objectively determine whether an adjustment is reasonable. And it would take into account things like whether that adjustment would have made any difference to the employee, the cost of that adjustment, the effect on other employees, the financial resources of the employer. And as a university, you're deemed to have lots of financial resources, although you may not feel like it, and the disruption any adjustment may have to the employee's activities. So those are all things that will be taken into account when you're considering what adjustments may need to be made. And the kinds of adjustments that may need to be made, there's a wide variety. It can be anything from adjusting duties, transferring duties to other people, to things like flexible working, altering hours, altering place of work, and so on. I think you need to review your relevant policies and procedures regularly, because what is reasonable in particular circumstances and particular adjustments may change over time. So make sure those relevant policies and procedures are kept up to date to reflect the law, but also best practice. I was going to mention today the National Disability Strategy, which was introduced by the government in July last year. But luckily, I was watching the news last night, and it was on the news that there was a successful judicial review yesterday. So there were 4 disability campaigners who brought a judicial review proceedings against the government in relation to the disability strategy on the basis that there wasn't sufficient consultation with disabled people and disabled groups in relation to the strategy before it was introduced. So that judicial review has been successful. So I think it's sort of back to the drawing board, consult with particular disability groups and disabled employees, and then the government is likely to introduce a new strategy in due course. But I think that goes to show that even the government needs to consult in relation to disability in the same way that employers do as well. So if we move on to my top tip 4, and that's managing return to work. And Charmaine's already touched on this, but as Charmaine said, a lot of employers are requiring people to return back to the workplace. I know a lot of universities are requiring people to come back onto campus. And you just, as Charmaine said, you need to watch out as far as employees who have a disability are concerned. You may have employees whose disability suppresses their immune system, or it affects the respiratory system, and so on. They may be particularly worried not only about coming into the workplace, but perhaps travelling to work as well. And you need to consider possible disability discrimination claims, failure to make reasonable adjustments, and if you dismiss, possible health and safety dismissals or detriments as well. I think it's important in those cases that you consult with the employee and that you try and really address their concerns. There may be things you can do, for example, like if they're worried about coming into work on public transport, perhaps changing hours of work so they're not coming into work at busy times and those kind of things. If you do move to if someone is refusing to come back to work, I think it's really important that you discuss everything with them. You really understand their concerns. You consider any reasonable adjustments, and that you only really consider perhaps dismissing that employee as a last resort once you've discussed everything else, including flexible working relationships, flexible working arrangements, reasonable adjustments, and trying to reassure that member of staff so that they can return to the workplace. I also think you need to ensure that you've got your objective justification arguments in place before you make any decision. You've got to have a proportionate means of achieving a legitimate aim, and it's got to be reasonably necessary in achieving that aim. So I think it's important, if you are making decisions in relation to disabled employees, to make sure you have that objective justification up front, that you've thought about why you're making a decision, what the legitimate aim is, whether there are any lesser measures you can put in place in relation to that particular employee, and that you document those concerns, that you do have a paper trail when you're, if in case you do have these decisions challenged either internally or in an employment tribunal. So that's the end of my top tips. So if we move on to the next slide, please. Before we move on to questions, I just wanted to quickly mention a new e-learning tool that we've developed. We've got a series of 9 short courses for HR and employment law managers on those key issues there. E-learning, it's a subscription service. And if we move on to the next slide, if you are interested in that at all, then please vote now, and one of us will get in contact with you to provide you with some further details. So that's it. We now have about 10 minutes for questions, if anybody has any questions in relation to anything we've talked about today, or anything else in relation to disability discrimination, although I might regret saying that. But any questions, please come forward.
We don't have any in the Q&A or chat at the moment, so literally first person to put their hand up gets a go. I think it's interesting what you were saying, Jane, about the need to carry out that proper impact assessment when you're dealing with objective justification. One of the things that I've noticed over the last few years is that I actually think that the higher education sector is better than most at baking in an impact assessment thought process to policy decisions, so that if it comes to a challenge on a discrimination basis, you're able to refer back to your paperwork and say, here's our thought process for identifying our legitimate aims and assessing their proportionality against the impact on people. So just a little well done to you all. But if you think that doesn't apply to you, it's definitely something that you should be thinking about making part of your decision-making processes.
Okay, I've got some questions coming in now. So if an employee requests to remain working from home when all other staff have returned to the office because they are a carer of someone who is clinically extremely vulnerable to COVID, would this be deemed to be a reasonable adjustment?
Well, I think that, do you want to take that, Jane, or?
Yeah, I can do.
Because that's associative reasonable adjustments, isn't it? Really,
it is associative reasonable adjustments, which you don't have to make, as I said. So you don't have to make those adjustments. Whether it could be direct discrimination, I think that's possibly unlikely here. From a practical point of view, I think you need to be consulting with the employee and seeing what can be done. But the reasonable adjustments part of it, no, doesn't apply in relation to associative discrimination. Bob, I don't know if you've got anything else to add.
No, I think it's as simple as that. Yes, there isn't an associative reasonable adjustment claim. So the short answer is no. The next question is, during the pandemic, we accommodated remote working / teaching, and now have some who are using this as a reason to continue to demand to work remotely. Yes, and that's not just happening in the world of HE. And we've had some specific inquiries about that point. And generally speaking, our view is that your employment contacts identify your place of work. And unless you have expressly said so, a temporary variation to the place of work caused by the need to react in an emergency to the pandemic and the lockdown doesn't vary that. There is no freestanding right to work remotely unless you've expressly agreed it. And so usually we would expect universities to be in a position to refuse or rebut that challenge. I don't think it's a solid position for an employee to argue from this, simply because in what has been the most extraordinary event of our lives, let's face it, that there's been a period of allowing them to work from home. They have somehow developed an implied right for that to be a permanent variation to their role. I think you would have had, well, yes, I think you would have had to have expressly said, we're permanently changing your place of employment, for that to be a reasonable argument.
I think that the only thing I would add to that is in relation to reasonable adjustments. If you are talking about a disabled employee and something has changed for example, or they're particularly vulnerable, or they're particularly worried about coming into the workplace, there may be a reasonable adjustments argument there. That's going to depend on a case-by-case basis.
Yes, and that's a very good point, Jane. And also, slightly more broadly than the sort of legal risk management, if you have employees who are simply fearful or cautious, engaging with them about the root of their concerns and trying to see if there's a way to alleviate it is a much more sensible way to approach it than you know, a three-line whip, if you like. The next question is, what is the position for pregnant people being asked to return to work? I'm happy to answer that unless Charmaine or Jane, either of you would like to.
Bob, I was just going to say that a lot of the things that you've just touched on would apply in relation to a pregnant employee, but I'd also say if there's any specific concerns that they have, obviously speaking to the employee and then perhaps conducting a risk assessment in case that's necessary to outline anything that might be of concern.
Yeah, I mean, you will have your obligation to make a specific risk assessment in respect of the working environment of a pregnant employee, and if it changes, you've got an obligation to conduct a new risk assessment. The government recommendations have changed in respect of pregnant employees, of course, so they're no longer being recommended to postpone taking the vaccine. They're being encouraged to take the vaccine, and there isn't the state of public health information is constantly changing, isn't it? But the current position does not appear to indicate that there's any greater degree of risk to a pregnant employee. But it's about looking at their work environment and seeing what can be done to alleviate any potential concerns just from a practical basis, but also complying with your health and safety risk assessment obligations.
We've got a question in the chat. Would a university be able to increase the isolation days, given the government's position is one of guidance?
Increase the isolation days. Well, I suppose that's a matter of your own COVID-related risk assessment, isn't it? So the short answer, I think, is yes, but it's going to have to be very fact-specific, and in doing so, you are going to need to be able to identify what particular risks you can find as the result of returning to work earlier than the minimum recommended government timescales. Both, I think, the 10-day and the shorter 5 or 7-day periods if people have clear lateral flows. You'll have to consider questions of proportionality, and it will need to be an evidence-based approach, essentially. So I believe it would be possible, but it would require a careful thought process. And in an HE context, it's probably likely to be the kind of policy implemented that would require some kind of involvement from the trades unions. If not full consultation, then at least notification of the proposal and an opportunity to feedback, I'd suggest. Although I imagine that would be a standard part of your approach anyway. What do you think, Jane?
I agree with that. I think you may find that the tribunals, the trade unions actually are quite supportive of that, given that they have raised health and safety concerns in relation to a lot of things. It may be that they think that a longer self-isolation period might be a good idea.
Yeah.
But I think it does all come down to the risk assessment.
We've got another question. Given the OFS insistence on face-to-face teaching and service delivery, does that provide justification for requiring employees to return to the workplace where they are delivering services directly to students?
I think it's a strong factor in your favour. You know, I would compare, I think the higher education position is starting to move starts to move closer to the school's position, where teachers, as a matter of course, are required to be in the workplace. I don't think you're quite there, but if you are going to be subject to any kind of legal challenge, either for putting in place a policy that is then attacked on the basis of being indirectly discriminatory, or ultimately because you're taking disciplinary action against employees who are refusing on the basis of a reasonable line management instruction, in either case, tribunals will be considering issues of proportionality. And if you have a legitimate aim of being obliged to comply with OFS directions for face-to-face teaching, that's going to be not just a legitimate aim, but a relatively powerful weight in the weighing up of impact against methods of achieving. And I can't think of ways of achieving compliance with that OFS directive short of requiring staff to be in. So that's a slightly long-winded lawyer's way of saying yes, but I think it's going to make a substantial difference in any kind of legal argument about and a university's insistence on staff being on campus.
I've got one more question, which is, we have a professional services employees who have been working from home for almost 2 years, who have not returned to the workplace at all, and no communications made to them about returning. Does this mean that they can rely on this being an implied change, as this is now beyond a temporary response to the emergency?
I think no, it is a response to the emergency. Temporary has lasted for a lot longer than perhaps was expected at the start of the pandemic. But I think no, but actually the sooner you communicate with people, the better, because the longer it goes on, the more likely it is to be implied. So I think you at least should be communicating with those people now and trying to get some of them back into the workplace, because yeah, if it goes on for much longer, then it may become an implied term of the contract.
Yes, this is the point at which any kind of reason for allowing them to remain away from work appears to be disappearing. So yeah, you need to take prompt action. Absolutely, Jane. I completely agree with that.